The names, addresses, and telephone numbers of each medical marijuana collective member are required for the permitting process. However, I must emphasize that this information is not subject to disclosure pursuant to public records requests. This is simply for purposes of performing the application investigation and compliance. Information confirming whether or not the proposed medical marijuana collective has ever had a similar permit or license revoked or suspended in a similar state or within the state of California at another location. And also, if the collective is a corporation, the verification from the Secretary of State, the bylaws, and most importantly, verification that the collective is registered with the California Office of the Attorney General as a nonprofit entity. However, incorporation is not required. The medical marijuana collective may be an unincorporated association pursuant to this draft ordinance, and in such case, a copy of the Articles of Association would be required to be provided with the application. Also, a copy of the operating conditions as set forth in the ordinance, initialed by each one of the members, indicating that they have read and fully understand the conditions required pursuant to such a permit. Also, finally, with respect to the application process, there are prohibited activities which I will further discuss, and each one of the prohibited activities, like the operating conditions, must be signed by each one of the collective members, indicating that they've read, they understand, and that they agree they will not engage in the prohibited activity. And the entire application will be signed by, again, each member of the collective, acknowledging that the information contained in the application is accurate and that they have personal knowledge as to the veracity of that information. Now, with respect to the actual permit itself, as I stated, there are required operating requirements, and those include distance restrictions. With respect to this particular ordinance, there is a 1,000-foot distance restriction that no collective can be located any closer than 1,000 feet from schools, parks, public libraries, state-licensed child care facilities, playgrounds, youth facilities, or any other medical marijuana collective. There are also exterior lighting and parking area restrictions that the collective must adhere to. Any exterior sign or interior sign must be unlighted. The location must be a secure premises. It must be equipped with sound-absorbing insulation, odor-absorbing ventilation and exhaust systems, and closed-circuit television for security purposes. The property must also have adequate centrally monitored fire and burglar alarm systems. And on the interior of the collective, there must be signage located in a prominent location advising the members of the collective that there is to be no diversion of marijuana for non-medical purposes. It is a violation of state law to do so, that the use of marijuana may impair a person's ability to operate vehicles, and that loitering at the location would be illegal and unlawful. Under the ordinance, medical marijuana collective permits are non-transferable. They cannot be transferred to another location. They cannot be transferred to another collective. With respect to the records that are required to be maintained on site at the location, the ordinance requires that the records, including the name, address, telephone numbers of the property owner, remain on site, the full name and address and telephone number of the collective members, and also the nature of their participation in the management of the collective. Again, the names and addresses of the individuals are not subject to disclosure pursuant to the Public Records Act. The full name, address, and telephone number of each member must be maintained who participates in the collective cultivation, the date the member joined the collective, and the exact nature of the member's participation. the full name, address, and telephone number of each member to whom the collective provides medical marijuana, and the collective member status as either a qualified patient or primary caregiver. Again, I emphasize that the confidential names, addresses, and phone numbers are not subject to disclosure. As far as the fiscal component of these required records, all contributions, whether in cash or of any kind, are required to be maintained by the collective at the location, an inventory record documenting the amounts of marijuana cultivated at the property, and also those amounts that are stored at the property at any one time. And the records shall be maintained for a period of 5 years. Any permit holder of a medical marijuana permit, as it is proposed in this draft ordinance, is prohibited from engaging in any cultivation, possession, distribution, exchange, or giving away of medical marijuana for any non-medical purpose. It would also be unlawful for any member to cause, permit, or engage in any activity except as that authorized pursuant to state law. And also it would be unlawful for any of the members to knowingly make any false or misleading or inaccurate statements with respect to the record keeping or any of the information provided in the application. Now, finally, no medical marijuana collective member shall cause or permit the sale, distribution, or exchange of medical marijuana cultivated at the property to any non-collective member. No medical marijuana collective member shall allow or permit the commercial sale of any product, good, or service, including drug paraphernalia, in the parking lot of the location or at the collective itself. No cultivation of medical marijuana at the property shall be visible from the naked eye or from the public view. No medical marijuana collective shall be open between the only hours of operation would be outside of 8 p.m. and to 10 a.m. the following morning. There would be no sale of marijuana or edible products containing marijuana allowed at the location. And in the event that those products were to be manufactured, for example, edibles, at the location, the equipment that would be necessary to cook, to manufacture these edible products would have to comply with all health requirements with respect to the equipment needed. There is a prohibition against allowing any person under the age of 18 to be allowed at the property. However, there is a caveat that if a qualified patient is a minor, they may be present as long as they're accompanied by either their licensed attending physician, parents, or legal guardians. Also, no medical marijuana collective shall possess more than 5 pounds of dried marijuana or more than 100 plants of any size at the property at any time. No medical marijuana collective shall possess marijuana that was not cultivated on site, either at the property or at a predecessor location that had been previously disclosed to city officials during the application process. No dried medical marijuana shall be stored at the property in structures that are not completely enclosed and secured. And no person who has been convicted within the last 10 years of a felony shall be authorized to engage in any of the management member responsibilities of the collective. The ordinance provides for enforcement of the prohibited acts and enforcement of what is required by means of criminal consequences as a misdemeanor or civilly as a nuisance. And any such violation would, of course, jeopardize the permit holder with respect to any subsequent applications within a 1-year period of time. Those are the salient points of the proposed draft ordinance, and I am available for any questions. Thank you.